All right. And Ms. Jackson, are you ready to proceed on your motion today?
I am.
All right. Ms. Stevens, are you prepared to proceed?
Yes, I am, Your Honor.
All right. Ms. Jackson, I'll allow you to argue your motion at this time.
The motion that I set forth to modify parenting time has come over an extended period of time. It was not a sudden decision. It was years since we had moved. Things have changed. Situations have changed. Some things had gotten better at a certain point. Some things got worse, and then now we've been on a continual decline of co-parenting, communication, and the like. And unfortunately, not only does that have a negative effect on both of us as adults, it also inherently has a negative effect on the child as well. Even if she is not privy to the conversations, she's been aware of the fact that, her parents aren't friends, to say it that way. There are more concerning issues that I have brought forth in the motion, and there are just things that when the motion was put in place, she was a toddler, or when the prior order was put in place, she was a toddler, and she's now in school with an actual schedule. So there are things that just need to be reworded.
What is her age now? Is she about 7?
She's 8.
8. Okay.
So some things are just administrative in nature to update based on the fact that she's no longer 3 years old and is 8. Other things, just wording needs to be more specific so that ambiguity no longer causes communication breakdowns. And there are definitely some larger issues that I take within the way that the parenting plan is currently written, and with issues that have continued with the emotional state of the child in regards to the situation.
Ms. Jackson, let me, I've had an opportunity to review the file, but this is the first time that I've dealt with a hearing regarding these parties. You live in Colorado, is that correct?
That's correct.
And where in Colorado?
Aurora.
All right. And Mr. Rankin resides in Park City?
Wichita.
Wichita. All right, go ahead.
I'm not sure if you want me to go straight down the line of my motion or address the issues that were brought up in the motion to dismiss first.
It's your motion. I'll allow you to present it how you see fit.
Okay. The first issues, obviously, that are the biggest issues probably to have in forefront are any violations of the parenting plan, which are listed under number 3, specific violations referencing back to the original parenting plan. Those were all of the things that Ms. Stevens had brought up in the motion to dismiss. No specific, I did not bring up specific changes within any of those. The first change that I asked for is later, but the issues that are brought up definitely do go towards changes that I did request. First one being the whereabouts when on vacations and extended trips with the minor child. Any change to the parenting plan that I requested, obviously I know and have no issue with it going both ways to both parents. I can't say that it has happened both ways because I have not taken the child out of the country. So the only example of that is a one-time occurrence. And I also have not taken the child out of state, short of taking her to the state in which Mr. Rankin lives. we had a lot of issues during a cruise that was taken out of country. I wanted additional information. Ted felt that it was not necessary to give me that information and stated as much as can be seen in Exhibit 1 of my response to the motion to dismiss. He felt, based on the wording of the current parenting plan, the only thing he needed to tell me was that he was taking her out of the country. And though that may technically have been the case due to the wording of the parenting plan, I feel like proper and effective co-parenting should not have been an issue to give more information when it was requested, given the fact that he was taking her out of the country. I had to obtain legal counsel in order to get that information that I asked for. I was able to get that once my, at the time, representation contacted Mr. Rankin about it. But I think that definitely needs to be updated within the parenting plan to include additional information just short of one of us saying, hey, I'm taking her out of the country. And it was brought up in the motion to dismiss that was intrusive. And I personally don't believe requesting additional information of, for the cruise, for instance, dock dates, travel dates to the dock, where the cruise is going, without forcing the other parent to have to find that information on their own, which I did end up having to do. Thankfully, I had the name of the cruise line and I was able to deduce which cruise it was, but I don't feel that effective co-parenting should force that situation.
Ms. Jackson, can you reference where in the existing order you're requesting this modification?
Within the parenting plan or within the motion?
Within the original parenting plan?
The original parenting plan?
Because you're seeking a modification of language in the original order, if I'm hearing your argument correct. Is that accurate?
It's not in the place that makes sense. So
And just so we're all on the same page, is the agreed order and parenting plan filed on September 17th, 2020, what you're seeking to modify?
yes. I believe the only time that it is actually mentioned, and this is also why it needs to be added and changed, is in the original parenting plan under C. It's actually, I interpret this to actually be regarding the residency, but this is what has been discussed before when the conversation was brought up, where it says, 2, removing the child from the state or the child's state of residence for a period of time exceeding 90 days. That has been Mr. Rankin's argument before, that he did not need to tell me because he wasn't removing her for longer than 90 days. We don't have a lined out specific verbiage for out of country travel or even out of state travel, which I think definitely needs to be added for both sides, so that we have a knowledge of where our child is, even when with the other parent.
All right, I understand that argument.
The next issue brought up specifically within the violations of the parenting plan, which leads to the change that was requested. Each parent is allowed reasonable telephone, text message, email, and video access to the minor child at reasonable hours without interference from the other party. There have been issues. He's brought issues up, so I will say that there have been issues on both sides. regarding the time in which a phone call happened, or most often a FaceTime video call that happens, be it when she is in the car, things like that aren't always the most convenient. And the language that is within the parenting plan is very rigid, and almost it's definitely a point of contention, almost a point of malicious compliance sometimes.
And again, when referencing the original order, can you point out where in that order you're referring to?
Yes. That one is number 11, which I believe is page 8 of the parenting plan. Again, at the time that this parenting plan was put into place, the child was 3 years old, and a toddler of that age is hard to keep on the phone anyway, even when it is a video call. So putting in that to have minimum telephone or video contact with the minor child on set days for at least X amount of time was justifiable at the time. That way we could ensure that the opposing parent at the time that did not have the child could have communication with her. However, she's older now. There's times where she doesn't even want to talk on the phone. Then it has happened on both sides. As I bring up in my response to the motion to dismiss, during this current parenting time, there was a time in which they had actually just gotten back from a weekend vacation of sorts. And I had sent the text to have her call. They said they weren't home. They'd be home later. I said, okay, have her call me when she gets home. She got home, found that some of the neighbor friends were outside playing. She apparently had said that she wanted to call the following day instead of that night, and that was fine. I feel like at 8 years old, she has the ability to know whether she does or doesn't want to be on the phone or at a specific time, rather than rigidly trying to force her to sit on a phone call for 15 minutes. I think at this point, it would be better served to further limit communication between two people who have had co-parenting and communication issues, to allow the child to have the autonomy to speak to both parents at any point that she wishes. My husband and I have previously gotten her her own cell phone that she uses when she is here. She has not taken it to Mr. Rankin's house. He at first did not agree to her thinking that she needed one. In some ways she doesn't. She's not on her own or alone at any time. It was more so that she had the freedom of conversation between other family members and her father without having to utilize one of our cell phones in order to do so. She's perfectly capable of utilizing it. In the motion to dismiss, it was mentioned that Mr. Rankin was open to the idea of her having her cell phone there, but that he wanted to have the control to say when it was or wasn't needed. I do take issue with one of us defining what is needed in regards to communication for her. If she is here and she feels the need to text her dad or call her dad, and it's not a Tuesday, Thursday, or Sunday, there's no reason that she can't do so.
What specifically what kind of language are you requesting? Is it just that the child should be able to communicate with either parent when she feels it appropriate?
More or less. Number 7 within the proposed parenting plan that I submitted would allow for her to utilize her cell phone that I do note is provided and paid for by myself. I have had no intention of requesting any financial reimbursement for the cell phone from Mr. Rankin, to be clear on that. But to use it for communications with the opposing parent that the minor child is not currently with, allowing her to utilize and retain possession of the cell phone for personal use, as well as not solely for the communication of the other parent. Thus being due to Mr. Rankin stated that if her cell phone were brought to his house, he would take it and give it back to her only to call me, which eliminates the natural flow of communication that she could potentially have with me while she is with him, and with him while she is with me. I did note that in addition, due to the nature and symptoms of her medical diagnosis of ADHD, she is only 8 years old, and therefore there are certain things that are harder for her, like remembering to charge her phone. It's an issue that we have here as well. And I think it's important that we have a common ground across both homes in order to help and assist her to learn. I don't think that this means that she is unable to utilize a phone. I just think she has certain issues with certain things due to a medical diagnosis. Cell phone's not the only thing she forgets to do, just like any other 8-year-old, and sometimes it's a little more because she does have that medical diagnosis of ADHD. It also, utilization of her own personal cell phone allows her the privacy that she has indicated to me that she does not have, or does not feel that she has while she is there.
Are you anticipating that this provision only apply to contact with either one of her parents and not with whoever she wants to be calling?
No, use of her cell phone. She has the phone numbers for at least 2 of her siblings, her grandparents, all saved in her phone. She does she contacts my mother on occasion. She does talk to one of Ted's other children as well, who's not always at his home. But the utilization of the cell phone being exactly how we all use a cell phone. Not to say that rules don't apply in households. We have them as well. She goes to bed, it gets plugged in our room. She doesn't have access to her phone all through the night, things like that. But and I would assume that there are cell phone rules for the other children in Ted's house as well. I don't know what they are, but even though they are a little bit older, I assume they probably still have rules that apply to them. But she has little games that she plays sometimes, no different than I feel probably any of us do on a cell phone. She is restricted on how long she is allowed to be on her phone. I feel that it would probably be the same way there, regardless of whom she was talking to or anything, but it allows her continued communication with other family members. And right now, I think she's only got one friend in her phone, but we do have I feel important to note, we do have parental controls on the cell phone. She does not have full access to everything. But I feel it would be important to not have specific days or times in which she is allowed to contact whichever parent she is not with. It just puts a hindrance on a lot of things, not to mention a hindrance on whichever parent is waiting for that phone call.
Right. I understand the argument.
The next issue, I don't know that there's a whole lot that really needs to change about wording, more just the parenting plan needs to be followed. Within paragraph 12 of our current parenting plan, it states, neither party shall make disparaging remarks about the other party's significant other, or the other party's family members in the presence of the minor child. And it goes on, I believe it is, let me make sure. Exhibit 3 that I submitted with my motion to dismiss is one of the most obvious forms of disrespect and disparagement that has come from Ted, certainly not the only one. There have also been comments from his wife as well, and from what the minor child has stated, his spouse's mother has also, she's indicated that she has also spoken negatively within earshot, not specifically to the child, but within earshot. There are a lot of communication issues that happen between Ted and I, which is why I believe it's in everyone's best interest for us to use a third-party communication application to help avoid issues like what he has me saved in his phone as, which was brought to my attention by the child. She thankfully did not fully understand what the words were, but she knew that it was not my name. And then
what is it?
In the second image on exhibit 3 at the very top, you will see what I would prefer not to say that.
Do you all not utilize a parenting app?
Not yet. Ms. Stevens did indicate that he would be in agreement to doing so, however.
Okay.
Within my motion, I did request that I don't know how it is normally done, but I request that the cost of that, which I believe can be done yearly, be split 50-50 between the parties.
Okay, go ahead.
The C under my motion to modify leads into the biggest request within the motion that I believe Mr. Rankin had an issue with, which is understandable. The minor child's mental and emotional well-being, as well as her own thoughts, feelings, and desires, I believe should be considered. I understand that at 8 years old, we're not talking about a 16-year-old who has, a certain level of perceived emotional maturity. However, 8 years old, you do still have feelings, emotions, and thoughts and opinions. I don't believe she should be controlling everything about her life, but I do think that her feelings should matter. She has indicated both to me and to a third party that she does have very strong negative feelings about a lot of things. My position has never been, and I've never stated that she hates or dislikes everything about her father or going to her father's house, anything like that. I do believe that negative and positive feelings can coexist within the same person about the same situation. And I believe that's what she is currently dealing with, a conflict of emotions where she feels certain things are incredibly negative, but there are obviously positive things. It is her father. She does love him. And that's just how it is. That can happen all the way up to adulthood, in my opinion. Due to that, there have been multiple times where she has requested not to go to her father's, which I have told her that unfortunately, I don't. It's not something that I can just decide unilaterally. She understands that I don't just have, complete control over that. She has indicated not wanting to go for as long. She has indicated not wanting to, go back after a period of time. Unfortunately, these are not things that she currently has control over. Again, nor do I believe that she should just be able to say, no, I don't want to go, because at any point a child could be, unjustly, ticked off at a parent for something, and that should not indicate whether or not she has visitation or parenting time, however it's worded, with that parent. But I do believe that I believe a reduction in time during the summer would benefit her. 4 weeks is usually pretty difficult for her. From what I understand from talking to her this time, the current parenting time has been positive, at least for the most part. She does not feel like she has the ability to speak freely about all aspects of things. So I usually do get an unload as soon as I pick her up. But I feel like a a termination of parenting rights or a complete removal of parenting time is not justified and not necessary. I also feel like should the relationship between the two of them be consistent in how they feel. Mr. Rankin has indicated he believes it's all positive, and our child has indicated that she does not believe it to be all positive. And should that change and things become, a better, more positive for her, there really wouldn't be any reason for that to, in my opinion, to go back up. And that would again be, if the child indicated, hey, yeah, I've been at dad's less, can I stay an extra week or something the next time I go, things like that. I feel like she's old enough to be able to indicate that things are more positive, that she feels more positive and happier when she is there.
So is your request for a reduction in Mr. Rankin's summer parenting time tied into this paragraph C on page 4?
In part, yes.
Okay.
It's also partially tied into paragraph D, where there have been choices that have been made that I do not feel have the child's physical safety at heart. Within the motion to dismiss, it was argued that Mr. Rankin follows all car seat laws, always has, and has always listened to what I say. Unfortunately, that is egregiously wrong. It has been a point of contention since our daughter was an infant as to how to properly install car seats, which car seats she should be in, can she move to a booster, et cetera, et cetera.
Is she in a car seat at age 8?
She is in at least in my vehicle, she is in a high-backed booster because she is very small and relatively short. So she does not pass the height and weight requirements to not be in a high back booster, at least not for the car seat that I have. And following the American Academy of Pediatrics recommendation and the highway safety recommendations, which is what I follow. I happen to have a car seat that it was one that was extended. You could use it for like 10 years, provided it was never in an accident. So it's very easy for me to alter it without having to change what seat she is in. I don't know what type of booster or car safety seat she is in within Ted or his wife's cars. I believe she's in something. I just don't know exactly what it is, because she indicated to me most recently when they had driven to Texas for to port for the cruise, she was told that she could get out of her seat and lay across the regular seat in order to sleep better, which obviously is not car safety for her size. And actually, I don't think it's indicated for anyone to do that. And that is just one particular occasion. There was another occasion where she said she was told not to tell me that she was not in her seat because it will just make your mom mad. Another instance of safety issues was she indicated to me that they went out to buy shoes. They frequent Silver Dollar City, where there's theme parks with amusement rides, and she, like I said, is kind of short. She is tall enough for the 48 inch, not tall enough for the 52 inch, I believe, 51, 52 inch. She indicated to me that they intentionally bought her tennis shoes that had a thicker sole, so that it was said to her she would look taller, to make her taller. And she said that she was taught how to stand with her heels slightly up to make herself appear taller so that she would be tall enough for the ride. It was also indicated on a phone call. I happened to be in the room putting laundry away, and overheard her make a comment to her father about it not being, that I had mentioned to her that it was not safe for her to be on rides that, maybe she really wasn't tall enough for. And the comment that was made, whether in jest or not, was, well, we got you on the ride. That's all that matters. Like I said, may have been said in jest. However, I don't find that particular situation to be something that is laughable in any manner because children have died. And I do think a disregard for physical safety, no matter how small, can be problematic and can be indicative of a much larger issue when gone on and not nipped in the bud, so to speak, so as not to continue physical safety issues. It also ties into paragraph E, where the minor child has indicated that she fears Ted. This is not at all times. This is not, just being in his presence that is fearful to her. It is certain actions, certain words. She has indicated, I would argue, normal parenting things, he raises his voice. Okay, we all do. He believes in spanking. I do not. It's a difference in parenting opinion, and I can't do anything. I can't do anything about his, his opinion on that. But he does have a significant history of physical violence when it comes to domestic issues, and she has indicated that she has seen what she describes as her father being scary or having scary behavior. She has also indicated to me that at one point she hid in the bathroom with her older sister while her stepsister was being yelled at, and at which time Ted broke her cell phone in his own hands. I don't know if that part was seen or if it was just a knowledge that she had based on what she could hear, but she did indicate that the two girls did hide in the bathroom during this altercation because they were scared. She has also indicated that she has fear of his spouse at times. Again, not 100% of the time. It's not her presence. It is certain behaviors. She has said that his wife has grabbed her arm before hard. That it feels like she's harder on our child than on other children in the home. She has also indicated that there's a significant disparity in the way that she is treated by her stepmother when her father is not around versus when he is. And she's also indicated that she has had fears before of her stepsister due to continued blame for things that she indicates she did not do. And one particular instance where she said that a bag was placed over her head and her arms were held down so she could not take it off. And it was done when she asked why that was done, it was indicated to her, well, because it was funny. I wasn't there. I can't say exactly what happened. This was the perception of, at the time, a 6-year-old having something happen to her. I do think that it is worth noting that though they were found to be unfounded, unsubstantiated, what have you, there was in fact a DCF report on both Ted and his wife. I don't have any information on what the one towards Ted was, short of what was in the very vague notice of findings that I received. I believe that one was emotional as opposed to physical. I know the one against his wife was physical. I did hear about the incident prior to finding out that anyone had reported it to DCF. I was accused of being the one to report it. I was not. It was not the first time that she had told me about a situation that was similar. So unfortunately, it probably did not have the same. I didn't get in an uproar and immediately contact Ted about it. But the same version of the events that she told me is what I was told from Colorado DCF that was told to them through the report. Again, I don't have any idea who made the report, so I can't say how clear, concise, or effective in communication that was. It was found to be, unfounded, unsubstantiated, and I can't argue with that. That's how it was found, but worth noting that it was there to begin with. And she has indicated to me and to my husband and a third party that she had been in fear of behaviors prior to this incident. I do request in the new, my proposed parenting plan. Figure out exactly where that is. Number 29, I do ask that physical discipline or punishment not be allowed in any way from any party in the minor child's life. Or in addition, the direct threat of physical discipline or punishment not be allowed in any way. I understand there's a fine line, in my opinion, between a difference in parenting types and something causing a fear within a child that is unnecessary. Spanking on the surface, I don't agree with. I was spanked as a child. I understand that it's a pretty common practice. However, it has caused emotional and fear issues within the child for being spanked. And I feel like there's a lot better ways to handle conflict with a child who is getting older as opposed to physical discipline. It's strange to me that we try to teach children not to hit and then we proceed to hit them. Paragraph F just speaks to little or no respect that I feel is shown towards my husband or myself by Ted or his wife, indicated in part by the exhibit showing what he has me saved in his phone as. I have absolutely no idea what his wife has me saved in his phone as, but I also know that at the time that I was told by our child, it was also not my name. She knows what my name is. She knows how to spell it. She said that's not what it is in Nicole's phone either. But I don't know. I have no record of what that one is or was, if it has been changed since. Paragraph G, there's been multiple accounts that the child has come home and told me that comments were made to her regarding being asked if she wants to live with them, and going so far as to suggest, well, why don't we just not take you home? I will say I find it important to note that these comments were not reported to have come from Ted. All of them were reported to have come from his wife. To my knowledge, he has not been the solicitor of any of these comments. At least not, our child has not indicated that he has. But comments nonetheless. Paragraph H speaks to efforts over time, communication breakdown, and those efforts have they've just been gone. There have been genuine attempts to bring conclusions to an effective and respectful manner and have not always done so. Like I said, there was a time in which it was much more positive communication, and then it has been a constant decline. Various things have been blamed on that. Me getting married has been blamed on that. There is consistent blame anytime there is an issue. There's consistent blame that, well, none of this would happen if you wouldn't have moved, which I believe is disparaging all in itself, given that issue was concluded once we had a confirmed and court-ordered parenting plan prior to my move to Colorado. Unfortunately, a lot of times conversations just have to cease. They have to be tabled because I am not perfect. I have contributed to conversations escalating when I have felt attacked and whatnot, as I'm sure there have been times where it's escalated due to Ted feeling attacked. However, I will no longer entertain conversations where I am cursed at, where I am called names, where insinuations are made, where accusations are made with absolutely no proof or anything behind it. So oftentimes conversations are just ended more or less. Unfortunately, neither of us should or does have the ability to block the other parent. So sometimes there have been times where the conversation has lasted one-sided much longer than it should have due to that fact, which I think can all be solved with using that third-party parenting app. I can't change the way he feels about me, nor can I change the way his wife feels about me or the situation. But I think we should be able to not say it to each other. Which also plays into the next paragraph, paragraph I, where Ted often fixates on past grievances and will constantly replay old conflicts. It's one thing to say it to me, however, it has also been indicated to the child that it is my fault for moving, for why certain things happen. Specifically, a conversation had happened once. Ted indicated they had gone to do something as a family, which obviously they're going to, and he was just having a conversation. And our daughter made the comment, oh, well, why'd you do that without me? And instead of just saying, well, you weren't here, or maybe we can do that while you are here, something to that effect. The comment, if you lived closer, you could have gone. And if you wouldn't have moved, we could have taken you, were made, which I feel are incredibly inappropriate, given that she does not have a decision in where she lives, where either parent moves to, nor was it her decision or her fault. And that one affected her after that conversation. We had to have a conversation as to why we moved in the first place. Paragraph J, Ted often places undue and unnecessary blame and accountability on me. Again, it goes into the moving. It doesn't seem to matter whether it is a conversation about homework or school or a scheduling conflict. Across the board, it has been an argument that the reason for it is because I moved. The reason for it is because I'm not single anymore. The reason for it is this or this or this. All things that have absolutely nothing to do with the conversation at hand. But worth noting that those things do happen. Paragraph K speaks to the removal of ambiguous wording. There are quite a few places, much like the communication of information regarding travel. There's no real wording for that one. And then there are other places where, like the phone call information, it says that for at least 15 minutes, obviously not taking into account whether or not she is busy or even wants to be on the phone, things like that. I think removal within my parenting plan, I think, at least in my opinion, I've successfully removed any ambiguous wording and replacement with more specific and updated verbiage to eliminate certain scheduling and communication conflicts. One specifically that I have no doubt will be brought up, and I do believe that I do touch on it in my motion and within my parenting plan. When we wrote the original parenting plan, it was written for holiday time for whichever parent had Christmas to have them until the 26th, and then the parent that had New Year's would get the child on the 26th, day after Christmas, and then for the remainder of the break. Well, she was in daycare, she didn't have a break, so to speak. Now she has a 2-week break that encompasses 1 week where Christmas is, and then of course the second week that encompasses New Year's. And that has been a point of, again, what I would describe as malicious compliance. The entire parenting plan, of course, is enveloped in the same phrasing of unless parties agree otherwise. Yet it has been told to me that their household accommodates me on those years where it says that he should get her on the 26th, because then of course he would have her for almost the full 2 weeks, when we had already prior agreed that it was the most fair for one parent to have a week and one parent to have the other week, alternating the week in which we have due to, Christmas and New Year's. So I believe that wording of certain scheduling things like that
You
would
need to
eliminate.
point out what language, what specific language you're seeking modification of.
Within the current parenting plan, all of the parenting time that is listed out starts at 7, which I believe is page 5, if I have that printed properly. And within my parenting plan, proposed parenting plan, I outline all of the times in which are indicated in the current parenting plan as well, for each of the holidays as to, odd years or even years, which ones that Ted has. However, I have added specific times for exchange because that has also been a problem. We had a very.
Could you point out to me by page number and location where in your proposal you've set forth your proposal or your modification?
Paragraph 4 under the proposed parenting plan. Some are very small changes. Like A, currently just says, Ted would have parenting time over the Thanksgiving holiday from Wednesday immediately preceding Thanksgiving to the Sunday following. That's where the missing information or more specific wording I feel would be beneficial. That has also been a conversational issue as to deciding when exchanges should be taking place. So really, like with A, all I did was add times that are indicative of when we have already prior agreed to have exchanges for the Thanksgiving holiday. B is where the current parenting plan has incredibly unfair verbiage for her current school schedule. Unfair for both parents in alternating years, saying that that Ted in odd years, Ted would have parenting time over the winter break from the day after the last day to the 26th. Well, on years where he has Christmas, in odd years like this year, he would have her for a total of, I think, 2 days, which obviously is not a fair situation in any manner. And it's also highly inconvenient to be making that drive so close together. And I feel that should be changed, which is what I propose in both B and C, being in odd years, which would be Ted's Christmas holiday, having the child for winter break from the Saturday after class, as opposed to driving so late in the evening in the dark in potentially inclement weather or conditions. So on Saturday at our roughly normal meet time at noon until Saturday the following weekend, which would encompass his Christmas holiday and give him one of the 2 weeks. Alternately, on years where he has New Year's, he would just have the second week of her winter break. And then it is an even split for that break, and it does not take the holiday away from either parent. Which is actually what we have done. It's just an argument every year as to why we do it and who is being accommodated for. And I think that changing the wording would be beneficial to everyone. Part of the reduction in time that I have requested is not necessarily a reduction in time, but more a sorry, I can't think of the word. Putting more time together in visits, as opposed to this issue of a long weekend that has been brought up multiple times between Ted and I, and also removing this one parent picks this time that could change every semester, every year, basically preventing any real ability to talk about it. The way that the parenting plan is currently worded when it comes to the long weekend that Ted gets per semester is that he gets to choose, regardless of what time frame he has to choose it. That has been an issue the last 2 years, though I will note that it only became an issue in the fall of 2023, and I moved in the fall of 2020. So within the motion to dismiss, Ms. Stevens pointed out that that his chosen times for a long weekend are always declined by me, which is categorically false. For 3 years almost, we had no issues whatsoever. The first issue arising in fall of 2023, when I indicated there was one specific weekend that was off limits. And I indicated that in March of 2023. That was due to my husband and I getting married that weekend. So it was one weekend out of the entire semester. There were, I think, 4 other potential options for him to exercise his long weekend. She actually has a fall break. She has a week-long fall break similar to a spring break, as opposed to having onesie-twosie days, like a lot of schools do. He wanted the entire week, and he wanted to pick her up the day after I got married, which obviously did not work out for a plethora of reasons. We were able to kind of squash the conversation during fall of 2023, but it obviously became an issue again fall of last year, where I had to then retain legal counsel in order to resolve the issue again because of the definition of a long weekend. He felt that 9 days, which is what the entire week encompassed, he could consider that to just be a long weekend, which by definition was found to not be the case. We ended up splitting the week, which there were other issues with that as well, but I don't see at this point why there's really any reason for, outside of Thanksgiving or, an unplanned occurrence, should there be reason for it, that there should be anything other than weekend travel. No one should be having to take off work anymore. The way that it was written before, it worked at the time, but really there's really no reason for either side to have to take off work in order to do this. Now, I do understand that Ted has a fairly wavering work schedule. Sometimes he does work on the weekends, but from what I understand, his regular job is a week job, and he does regularly officiate sports. But if we were to accommodate all of that, then there would really be no specific day during certain times of the year that he could travel effectively. So as opposed to having this long weekend, as a definition and have it change from every single semester and have this be a continued point of contention, I suggest that that we kind of split the time so that I also have the ability to spend non-school time with her. I have requested that of Ted before. Unfortunately, I was met with a negative response because I don't have a lot of time with her outside of school. And obviously I don't want to take her out of school in order to do certain things. So I asked for a little leniency, was not met positively with that request. So I suggest that in even years, he have spring break, in odd years, he have fall break, and we alternate the two. That way there's no extended long period of time in which he would not have her or not see her. If it was spring break every single year, there would be a long portion of time within the fall every single year in which, or I should say every other year specifically, if he didn't have Thanksgiving, in which he would not have visitation time, which I'm not attempting to I'm not attempting to do. So I have it, my proposal is for on the even years in which he has Thanksgiving, and there is that time during fall, those even years are also the time that he has spring break, which cuts the spring semester up as well, as opposed to him having fall break and Thanksgiving, and then there being a large gap in spring. Trying to make that the most effective over the entire calendar year as possible. The biggest, and understandably the biggest issue that I believe that Ted has taken with my request within my proposed parenting plan is the reduction of time during summer. This being due to a plethora of things that were lined out within the motion, and not having the ability for the child's thoughts and feelings to have prior been discussed or counted towards anything. 8 weeks is a long time for anyone to be doing anything. We do have it split currently it's written out as a 4-1-4 split in weeks. We do often have to, the last 2 years, actually, we've had to alter that, which has not been without issue, but we have resolved it due to her participation in dance. She has a dance recital with the current studio that she is with, happens to be in the beginning of June, which happens to fall within his currently laid out parenting time. Like I said, we have been able to adjust that, but I think it would also be best to, as I have in the parenting plan, include verbiage to that same effect so that continued conversations don't have to be had about whether something is or isn't fair for one parent or another. He has not lost any time in regards to summer due to the dance recital. He has indicated that he doesn't necessarily find it to be the most important, but to her it is. So I would like for that to be taken into consideration when when and if wording is changed for summer. Like I said earlier, I don't believe that a complete reduction in all parenting time is something that is necessary, because I don't believe that it is 100% of the time that she is miserable or hates being there or anything like that. There are definitely positives that she has brought back from being with her father before. But she has indicated many, many times to me that 4 weeks at a time is a lot and doesn't want to be there for that long. Or after the first section of time, she really doesn't want to go back. Thankfully, that has, as she gets a little older, it has gotten a little better. She's able to handle her emotions more and is able to get through it without as much issue. But I believe that a reduction in time, and at least until which time the two can be on the same page with how they feel. As I indicated earlier, Ted believes it's all positive, and our daughter has not indicated as much. But if things were to change, then the ways that are helpful to her, and she was to feel more understood and more emotionally supported, I feel like that would change her outlook on even being there, especially for longer periods of time. Our current parenting plan in paragraph F indicates Ted having additional parenting time if he will be present in the Denver area and provides at least 2 weeks notice. Unfortunately, this is another means of ambiguous wording causing problems. The way that it is currently worded basically makes it seem as if I have absolutely no control over anything. If he's here and he tells me 2 weeks in advance that he'll be here, I don't have any say. And obviously some things are planned longer than 14 days beforehand. So I do believe that the verbiage needs to be changed. And I believe to be the most fair and inclusive, there should be an addition to, if I happen to be in the Wichita area, I do have family. I'm from Kansas, and I do have family in Kansas. And should I go visit them during his parenting time, maybe be able to take her out to dinner with my mother, or my sister, what have you, would be nice. Currently, there is no allowance for me to do that. And due to the co-parenting issues and communication breakdown, I likely would not be able to do that. But I do believe it's also important to remove the ambiguous wording that that just states that if he is here, then he can have her. As she
What
gets
kind of
pushed-
language are you proposing?
Specifically changing it that if he will be present in the Denver, Colorado metropolitan area and provides me with at least 14 days notice of his intent and has coordinated agreement. Meaning that he says, hey, we're planning on being in Colorado, anything going on. And I have the chance to say, actually, she does have this going on. So the rest of the time that you're proposing to see her would be fine, but maybe she has a birthday party or maybe she has something else going on, as opposed to him just being able to say, well, I'll be there, so I'm going to take her.
Is that language that's in your proposed parenting plan?
Yes.
And where is that located?
Paragraph G and paragraph H. The following paragraph is where I have proposed that it, the same language, but on the other side for me, if I were to be in Wichita. The only change being obviously the end of paragraph G, stating, Ted shall bring the minor child back to Adrian prior to any scheduled extracurricular activities. More regarding, sporting events, things like that. She would often have a game or a practice or something, which may very well happen there. She's not been enrolled in any sporting events or programs that I am aware of, but should that happen over, during the summertime, things like that, obviously that would also need to be taken into account. I would need to get her back to him prior to that. But within both of them, I believe, make sure before I say that. Yes, time pursuant to this paragraph shall not interfere with Adrian or Ted's holiday parenting time, obviously respectively, and time pursuant to this paragraph shall also be subject to the desire of the minor child. Just because I happen to be in town or just because Ted happens to be in town doesn't necessarily mean that she's going to want to give up whatever is planned in order to make an adjustment. And I understand that. And I think that should be taken into account. She may not want to forego a birthday party in order to do something different when she had planned to be with her friends. And I do find that to be important as she gets older. That is the paragraph 8 is the last paragraph in the parenting plan, and within, I believe, yes, within the current order, regarding specifics on parenting time. It then goes into where we meet for exchanges. We meet in Colby, Kansas. It's the most convenient place. It's never been an issue outside of inclement weather, in which case we've had discussions, where to meet, altering days, things like that. There's not a whole lot you can do about that. There has been an issue with it not being Ted more often than not. And it was within the motion to dismiss, it was brought up that there have been a few times, there have been unfortunately more than a few times. The verbiage of the current parenting plan states a bona fide workplace or medical emergency that prevents a party from making the exchange, in which case a spouse or significant other or family member can do so. However, it does not state an ongoing or recurring workplace obligation, which I believe the argument in the motion to dismiss was. He does have with the sports officiating that he does, depending on the time of year, due to the sport altering what days he may be on the field. Obviously, it does create a much larger issue for him to be able to be there. Which creates not a bona fide workplace emergency, but a recurring obligation, which could speak to whether or not he's able to do it if the reliance is being put so much on his spouse. I have only had one occurrence in which I was not at an exchange. It was at the end of my pregnancy, and I was told I should not be driving that far. I believe that paragraph J.
Which document are you referring to?
Of the parenting plan.
The original?
The proposed parenting plan. It follows down from here. Paragraph J of the proposed, paragraph I of the current is in regards to airline transportation, which has not been the case and believe remains unchanged. It just states that he will take her to Wichita Airport. I will take her to the Denver airport. I do ask that it be changed, the verbiage from paragraph K, where it states that she should need to travel not alone until the age of 10. I ask that it should be in paragraph L, that it be changed to 12. Just given the altering environment of our world, I think that should be set a little bit higher before she's set off in an airport like DIA by herself. And that she not be allowed to travel between 12 and 14 as an unaccompanied minor unless there is a direct supervision of an airline employee, which is easy to set up. It doesn't cost any additional. I also don't know that that would be too much of an issue, as obviously we tend to just do car transportation a majority of the time. I have changed one bit of wording from paragraph L of the current parenting plan, stating that I will provide Ted with all school records, report cards, and school schedules when they are available. I am asking for the change of verbiage to say that I shall provide Ted access. He does have access, and I can give him the information for additional login information for the portal, as opposed to me trying to provide copies physically to him. It would be much easier for him just to be able to access all of it online, as I can as well.
And where is your proposed language?
Paragraph M, the following paragraph. Paragraph M of the current parenting plan deals with the exception of a prior subsection regarding parenting time. The minor child's extracurricular activities shall not interfere with Ted's parenting time. In the proposed parenting plan in paragraph N, I am requesting a change in the wording. The way that the wording is now makes it seem as if her life is interfering with him, and I don't believe that that's necessarily how he looks at it. It's just how it can be perceived in writing. The older she gets, the more there are going to be important practices or games or activities. Obviously, probably more so in high school, but if we take care of the verbiage now, we don't have to mess with it later. So I have proposed that rather than saying that it shall not interfere with his parenting time, that it shall not intentionally interfere with his parenting time, meaning I am not going to schedule something intentionally during his time and just expect for him to deal with it. Obviously, I don't have control over sporting events or school events, but I believe that the additional verbiage that I've added may be beneficial to our daughter as she gets older. Additionally, Ted's parenting time shall not intentionally interfere with unique events, either social, school, or sports related, that the minor child is involved in or would like to attend. These events include, but are not limited to, dance recitals, formal or informal school, social or club functions, practice or regular season games that, if missed, would disqualify their minor child from further opportunities within the season or year. Should such event occur during Ted's scheduled parenting time, the parties shall work together to come to agreement for Ted's parenting time to begin at a later time, end at an earlier time, or be switched or added on to another scheduled parenting time should it allow as much so that Ted does not lose out on parenting time and so the minor child does not sacrifice her commitments and desires due to either party. The following paragraph 5 of the proposed, 9 of the current, just states that law enforcement should direct to assist the parties, though I don't know that they actually do because it's civil. Paragraph 6 of proposed 10 of the current, parties being admonished that disobedience of the parenting plan may be considered, contempt of court. I don't believe anything has changed with that, short of I believe that it would be beneficial to add the sentence to the end stating the parties are aware that an agreement between parties outside of the terms of this parenting plan does not constitute disobedience of the parenting plan. That's been a point of contention before, where if we agree, then one of us isn't following the parenting plan, or that we are cherry picking the parenting plan by agreeing outside of it.
I'm going to stop you here for a second. Have you had any conversations with Ms. Stevens or Mr. Rankin about whether or not any of these issues are agreed upon, or any?
I was not contacted by Ms. Stevens at all outside of the motion to dismiss.
All right.
And that was done in the middle of last week. There wasn't, unfortunately, would not have been a lot of time anyway, but that is the only interaction that I have had.
And unless a paragraph in your proposed plan is there's a suggested modification, if we could just kind of move through these, I'd like to take about a 5-minute break right now. It's 2:31. Let's reconvene at 2:36.
Sounds good. Thank you, Judge.
Pardon?
I said that sounds good. Thank you.
Okay, we'll be in recess for 5 minutes. Somehow my thermostat in here got turned up to all the way warm, so I'm roasting, so hopefully it'll be a little cooler. All right, we'll go back on the record, same appearances as before. All right, Miss Jackson, you may continue, and I'm not trying to take away your time, but if there's portions of this proposal that don't modify anything that's in the current plan, if we could breeze over those and just discuss the portions that you're seeking modification of, please.
Absolutely. We left off at, going off of the proposed plan, we left off at 7. We've already briefly touched on it. It's regarding the use of a cell phone. So I'll skip over that one. Paragraph 8 would be in addition to, there really isn't one specifically in the current parenting plan short of just that one line stating the Tuesday, Thursday, Sunday for at least 15 minutes. Just asking that the minor child not be forced to have certain communications with a party at any time, taking away that very strict day, time, or time frame of a phone call, allowing her to have that agency herself. She can communicate via phone call, video call, text message without issue, and I believe is capable of deciding which avenue she would like to utilize for those conversations. If she just wants to send a text message, hey, I love you, hey, hi, whatever. However, if either party cannot reach the minor child via her phone, we are talking about a minor, after allowing a reasonable time for a response, then the parties may contact each other in order to get in touch with her. Obviously, we don't always have our phones on each other, so at all times, sometimes she puts her phone down and walks away and does something different. So it's understanding that you may have to get in touch with the other parent sometimes if need be. Paragraph 9, this is in the current parenting plan in part. Paragraph 12, about neither party making disparaging remarks about the other party or the other party's significant other. However, I have added, due to reports from the minor child, specifically that I personally, and I believe at least on one occasion, my husband was referred to as something outside of our legal names, this being also including the phone naming convention. Just ask that both parties shall refer to all parties involved by their legal name only. This would include spouses, children, etc., or by referencing their respective role to the minor child, your father, your mother, etc., and still allowing no third parties to make commentary to or around the child. Paragraph 10 also has been added. It's in regards to the same, however, is due to comments that the child has made to me that there have been rather negative comments made about her to her, not regarding the parents. She's been told that she, specifically, you're not as smart as your mother tells you that she is. You're not as smart as you think you are. Comments like that had a very negative impact on her vision of herself. And I think it's important not to make disparaging remarks to or about her where she can hear it. We may not always feel positively about a situation, but I don't think she needs to be involved in hearing it. 11 is the same. 12 is the same. I believe 13 is the same. Apart from the final sentence, in addition, neither party or their significant other or spouse threaten the minor child with not returning her to the opposing parent. That going back to the comment that I reported she made to me saying, well, we can just not take you home. 14 is in the current parenting plan under 17. I do believe it is important that she know that that she continue to know and be known legally and publicly with her last name. That is her last name. It is the same as her father's. However, I think that it'd be important to allow her to decide in part what she refers to her non-biological parents as. Obviously, if I wanted to be called something other than mom, obviously that's a different situation. There's a lot of different names that go into into titles. But she has asked before if she is allowed to call my husband dad in any version, and I've had to tell her no, unfortunately. We just call him Niall. That's his name. Call him Niall. I don't know if the indication has been on the other side, but if a step parent is important enough to the child, I think she should be allowed to call them what makes her feel the most comfortable. And if that happens to be their name, then that happens to be their name. She actually has a plethora of names that she calls my husband outside of his name that are not dad, father, or anything like that. They just call each other all sorts of random things. But I think it's important to allow her that agency to have that connection with a step parent. 15 is the same, I believe. Obviously, that's already been discussed as to how that has been problematic before, but I don't believe any changes have been made. 16, and also a couple of other paragraphs within the motion to modify actually tie back, the verbiage ties back to the first request within the parenting plan and within the motion to modify, where I ask for sole legal custody in regards to decision making. We have joint legal custody now where I have primary residential. There have been a large number of issues when it comes to specifically with medical care, with medical professionals having advised or prescribed or diagnosed care, and Ted disagrees with it and has sometimes refused to give the medication prescribed, has indicated that he didn't believe a diagnosis, has understandably asked for additional testing or confirmation testing. It has been given and it still was not to his satisfaction in order to give a prescribed medication. We currently have a situation where our daughter is not 100% able to go through a night without having an accident, which happens with a lot of children. And this happens to be the one thing that she has had where she has been slightly underdeveloped in a situation. I don't know what all has occurred in Ted's house, but it has a lot of different things have been tried in our home in order to aid in this, both the medical situation and just to help her feel less negative about the situation, given she does not have control over it. And during her last well child check, the yearly well child check, she was referred to a specialist, a urologist, to ensure that there was no underlying medical condition that could be causing this problem. However, in order to get her in with a specialist, that would fall under a situation where I need confirmation from Ted that, that we can do so. I ask on multiple occasions explaining why she was referred. I've never been given permission, so to speak, to get her in with a specialist, and it is hindering her being able to get in. There have been, on top of medication issues of things not being given, the child has indicated that her main diagnosis, the mental health diagnosis of ADHD, she does not feel that her father, as she has stated, she doesn't feel that her father cares. She doesn't feel that her father understands her, and that he doesn't believe that she has it. He has indicated to me on numerous occasions that he doesn't believe that it's that issues are not ADHD issues, they're accountability issues, and that it's my parenting that is the problem, not the underlying medical condition, which is her diagnosis, which also hinders a lot of things. Part of major decision making is also educational, and Ted has not been involved in a lot. He did not fill out any of the paperwork from the school or from the pediatric neuropsychologist, psychiatrist, when we did her testing to find out she had ADHD. There was a plethora of paperwork, and he did not fill it out, stating that he was too busy. We have had multiple phone calls or Zoom meetings made, because I was in person, but the Zoom meetings were made for parent-teacher conferences, for 504 meetings for accommodations for her in school due to her ADHD diagnosis. He has not participated in those. There was another instance where we arguably needed to change her medication for her ADHD, and obviously in order to do so, it takes both parents. In the state of Colorado, you're required to have permission from both parents in a joint custody agreement. And Ted asked for an additional appointment with the prescriber, which was fine. I made the appointment, even checked with him ahead of time to make sure the timing would work for him to be on the call as well. And then ended up, he was not on it. I believe he was out of town. These are just singular situations that have been going on over time where he is not involved, or doesn't put himself in the position to be involved, but I still have to wait for confirmation. And like right now, she's waiting to be seen by a urologist because I don't have permission, and I don't have the ability to just make that appointment without the potential of a negative situation happening for me by going against what he says he wants, or in this case, what he has not indicated at all. I also have kept track of countless times where I have text to update information or ask a question in regards to education or medication or medical at all, and have been completely ignored. Thankfully, most of those are updates as to, hey, we had her 504 meeting, for example, and this is what we went over. No response. Not even an acknowledgement of getting it. So I think that asking for sole legal custody is justified for those reasons alone, not to mention all of the other variety of things that have been discussed already. But that to say that number 16 is worded the way that it is worded due to my request of a change to sole legal custody for decision making, stating that I shall inform Ted as opposed to the wording that it currently states of us discussing before something happens. 17 is the same, however, not, as I stated, not been followed in all situations, referring to the giving prescribed medication as prescribed. And I do believe it's worth noting within it to include medication that is sold over the counter due to pricing or pharmaceutical allowances. This due to the fact that our child has been on over-the-counter allergy medication for both allergies and eczema. And the eczema is more controlled from the inside to the outside, which is why she's on the allergy medication. But because it is prescribed, not necessarily recommended, however, it's over the counter, so insurance doesn't pay for it. I did actually have it run through insurance to see what would happen, and it was twice as expensive. But he does not feel that she needs it, and believes that because it is over the counter, therefore not coming from the pharmacy, therefore not a prescription, that it does not count as he's not giving her prescribed medication as prescribed.
So your proposal adds that language? Or that's already in the original order?
It is in the original. I just added the verbiage of over-the-counter medication due to pharmaceutical allowance. 18 is an alteration from where's that one? Number 20 in the current parenting plan, where it says that I will provide clothing for the minor child. This has not been an issue for a long time. It's just a verbiage change that needs to happen to be more accurate. I don't provide clothing at his house. He provides clothing during the time, and shoes and such during the time that she is with him. 19 is the same. 20 is the same. 21 is the same in part as number 29 of the current parenting plan. We share uninsured medical expenses at a 50-50 equal divide. The only thing that I don't want to make any change to that. The only thing that I ask is that we put a time frame on reimbursement. Because it's my insurance, and obviously most of the time I'm the one taking her. I'm the guarantor on all of her medical accounts, and I often pay for her medication, her co-pays, etc. And it can take upwards of 90+ days to get repayment back for Ted's half. I keep track with an Excel spreadsheet. All requests have been requested by Ted to go through. It happens to be his wife's PayPal account, which is fine. It doesn't matter to me, whether it goes to her or to him. It may be better for him to have an account. I'm not, because she's not a biological parent. I'm not sure. Right now, I have one that is over 120 days since the original invoice date that I have not been reimbursed for. So I would ask that it be 30 days. Unless, of course, larger balances can obviously be problematic. If she were to have surgery or some extenuating circumstance that caused a very large bill, obviously, hundreds of dollars is not easy to just come by out of nowhere. So if she had a $500 bill for something, obviously $250 is better, but not necessarily easy. So there is verbiage in here, if we were to make agreement that, 125 one month, 125 the following month in that example, that would be acceptable for larger amounts. I don't see any reason for that, but when I get invoices, I have to pay them usually within 14 days or a payment plan. So I feel that 30 days is appropriate. 22 is basically just 22 is just saying there's no child support, which encompasses like 3 pages of our current plan, explaining as to why and explaining it down to $0. So I don't have all of that in there. It's just there is no child support. 23 is, I believe, the same. We may not actually have 23 in there anywhere regarding registered activities, providing that information to the other parent. We may not actually have that anywhere in our parenting plan. 24, I have added due to the events that the child has told me about. One I mentioned earlier regarding the bag over the head, not having the minor child be in the sole care of the other children in the home. More specifically, the younger, 2 of which I believe one has moved out, is now an adult. One is older and likely hardly home anyway. But most specifically regarding the situation that I discussed, without specifically calling any one particular child out, because we are still talking about minor children that make mistakes and find things to be funny that aren't necessarily funny. but it doesn't mean it didn't cause emotional damage or issue for her at the time. 25 has been added. Both parties will ensure to the best of their ability that the minor child's allergens, both minor and major, are avoided. Our child has been diagnosed with an oral sensitivity allergy, specifically to pineapple. And she has told me on 2 different occasions that Ted's spouse has intentionally given her something with pineapple in it. Now, I am not going to say whether that was completely intentional or malicious. I'm not going to suggest that it was, just that the child told me that there was a smoothie she knew had pineapple in it. She didn't want to try it. She was told she had to try it. And, she didn't appreciate the fact that she had to try something that she knew could bother her mouth and throat. I feel like it's important not to give allergens of any kind to the child. Number 26 and 27 are moot at this point. At the time that I wrote this, it was not. However, since I believe at least prior to spring break, which was March of this year, she does now have a proper bed that she sleeps in by herself. She also has a dresser as opposed to another vessel in which to keep her clothing. It was brought up within the motion to dismiss that these things were not the case. She slept on the floor, a couch, or an air mattress for a number of years after sharing a bed with a sibling. Once they became too big to do so, that's when the other options were in place. And she indicated that she often chose the couch because it was the most comfortable. She also indicated that her clothing was kept in a bucket or tub that she had to dig through in order to find something. Thankfully, that has been remedied, but I do think it's worth noting the amount of time it took in order for that to happen. She was incredibly excited to tell me about how the top drawers of the dresser were for her sister and the bottom drawers of the dresser were for her, and she was excited not to have the tub anymore. It indicates how she felt that her things were being treated and how she was being treated. Along with this, she felt like because she didn't have a bed, she described it as, I don't feel like part of the family. So I think it's incredibly important and positive that she now has that, but worth noting how long it took. Number 28 is incredibly important, and I don't know how else to describe it outside of it's incredibly important. She has come home multiple times and has been in the care of my mother during Ted's parenting time, where the condition of her undergarments were less than anyone should ever really have to endure. They were hand-me-down undergarments, which I find to be inappropriate anyway, given the price point of a package of new undergarments anyway, being very low. I actually still have a pair of them, and I did not include a picture of the condition because I felt it might be inappropriate given they were a minor child's undergarments. They were torn, they have been stained, and they are not new. Hand-me-down from one or both potentially of the 2 older siblings that female siblings in the home. Hand-me-down clothes by themselves, there's absolutely nothing wrong with, whether it be from a sibling, a friend, or a secondhand store, it doesn't matter. But underwear I find to be different, and I do believe that she should be given new underwear. 29 was already touched on, asking for physical discipline to be discontinued in all manners by everyone involved in the child's life. I just feel like there's a lot better ways to do things than the even muted down physical violence, but that's still technically what it is, in my opinion. 30 encompasses the third-party co-parenting app and the use of, with the application cost being split between both parties. I would also like for it to be, for the verbiage to be that the communication about and for the minor child occurring only between Ted and I. I know in obviously certain circumstances, there's reason for, the spouse to if they're the only ones with the child, obviously outlying circumstances like that. But it has been told to me that when it comes to scheduling, I have to talk to his wife about it because he doesn't have, scheduling with his own work, things like that. He doesn't, she's the one who does the scheduling, or she's the one who pays the bills, things like that, which may well be true. But outside of small occurrences, I think that the communication about the child should be between the biological parents only. It has created a lot of hostility before when his wife and I have had to communicate. I have ceased almost all communication with her because of the condition of the communication. And I think it should stay between the two of us. 31 is the addition to and specification of pertinent information regarding whereabouts on travel. Like I said in the motion to dismiss, it was described as intrusive. And I don't believe that asking for travel dates, both departure and arrival, locations of stay, duration of location, especially for situations like a cruise where you are bouncing from port to port, how the minor child can be reached regarding international travel, which obviously would not be an issue if she still had her private cell phone, because then international calling can be added should it be necessary. Flight times, obviously train is not used a lot, but train times, bus times, things like that. I don't believe that to be intrusive. I believe that just to be information of safety being provided to the other parent. And I have no problem with providing that should it be the case within our family to be traveling. My husband does not have family here. He has family in another country. And should we be able to, travel outside and go visit his family, that information would be given to Ted as well. 32 was added because I was informed by Ted that his wife was in fact in the papers when obviously no one outside of he and I or a discussion of a person is actually involved. I just believe it should be added for the continued reminder that this parenting plan and all rights included pertain to Ted and I only, and that our spouses do not gain rights in legal matter to the minor child at all just because we are married. I believe that covers the entirety of my proposed parenting plan. And I believe everything within the motion for reasoning has also been touched on.
Right. So does that conclude your presentation, Ms. Jackson?
I believe so, yes.
All right. All right, Ms. Stevens, I'll give you an opportunity to respond. And what I think would be of benefit and pare down further argument is if there are some of these proposals that your client is not objecting to, if you could so note those along the way. Otherwise, I'll allow you to respond at this time.
And Judge, if you don't mind, as I respond, I'll also argue my motion to dismiss for the sake of time, if that's okay.
Okay, I think that'd be appropriate.
Okay, thank you, Judge. I want to start by explaining the purpose and the context behind the parenting plan that currently exists from 2020. Ted and Adrian came to that agreement. The parenting plan was put together in a very specific way because at that time, Adrian was moving to Colorado, taking the minor child with her. The current parenting plan allows Ted extensive time over her breaks to account for the fact that the child lives with Adrian through the school year and most of the year. Further, Judge, the existing parenting plan lays out specific calculations which bring his child support obligation down to 0. And the parties currently have joint legal custody because both parties are closely involved with the child's life, and they should have a say in the major decisions on her behalf. Now, Adrian's filed this motion to modify the parenting plan, and my understanding of why we are here today, Judge, is because she's requested sole legal custody of the minor child, which my client is objecting to, obviously. And she's also asking that the court reduce Ted's already very limited parenting time. And we are objecting to reduction of his parenting time, given that it lines up with the child's school schedule. To the extent that we can make that clearer in the language of the parenting plan, set times if we need to, in light of the fact that she's obviously grown up, changed schools, things are different. We're open to negotiating that, Judge. But what I mainly want to focus on today is the request for sole legal custody and reducing Ted's parenting time, both of which we very much disagree with. So as I mentioned in my motion, we're asking that the court dismiss her motion to modify the parenting plan. Like I said, if that's dismissed, we are open to negotiating with Adrian on some of these smaller details that she brought up today. There are a lot of them. I didn't take a specific list down. It would take a side-by-side comparison of what's going on here. We're open to negotiating that with Adrian. As she stated, there wasn't a lot of time after we filed our motion last week to have those conversations, but we're open to doing that. Our biggest thing is making sure that these parties continue to have joint legal custody of the child, as they always have, and to make sure that Ted's parenting time remains at the same amount of time. Specifically, the summer parenting time, where currently he has 8 weeks, and she's attempting to reduce that down to 5, which we do not think is warranted in this case. So in essence, Judge, we're asking that the court dismiss the motion to modify the parenting plan, continue to maintain the status quo by enforcing the current parenting plan while we negotiate some of these changes that Adrian has brought up, and also to award Ted his attorney's fees in responding to the same and in this hearing today. Like I said, Ted is in agreement that certain parts of the parenting plan have become impractical over the last 5 years. And at the end, I'll note some specific things that we're open to changing and negotiating, such as use of our family wizard. I think that's great. I think that would help these parties communicate very well. We're in agreement with that. But we're in complete disagreement that any of the issues between these parties warrant Adrian taking sole legal custody and taking parenting time from Ted. So I'm going to give you some examples of some of the things that Adrian has alleged today and in her motion that are complete exaggerations to the point where they are false. Some are entirely false. The first has to do with Adrian's allegations that Ted and his wife made comments to the minor child about not taking her back and making her live with them. Those comments were very exaggerated. Ted remembers that conversation with the child. They were having a lighthearted conversation about how much they enjoy having the minor child with them during Ted's parenting time. They made a comment to the effect of, "We wish we never had to take you back." That was the extent of it. Very lighthearted. There was no suggestion that the child was not going to be returned to Colorado or returned to her mom. The child has been at every single exchange on time like she's supposed to. No one has threatened to not follow the parenting plan in that regard. The second one is Adrian's allegations with respect to the child's medication. Those are also very exaggerated. Ted would counter that the only time the minor child has not received a prescription during the scheduled time was during a family vacation where there was a change of routine and a couple of days were missed. But past that, she receives her prescription as she's supposed to. And this was clearly not an intentional withholding of the prescription. Adrian claims in her motion that there are certain emergency inhalers that have gone unused while the child is with Ted. These are emergency albuterol inhalers, Judge. These are not supposed to be used on a daily basis. They're supposed to be used on an emergent need. So the fact that they're not used during Ted's parenting time is not an indication that he's withholding these inhalers from the minor child. It's an indication that she may not have needed them during Ted's parenting time. Adrian makes an allegation that Ted specifically bought the minor child shoes with thicker soles and told her to stand on her toes to get on rides at amusement parks. Ted wants to make clear that this was a conversation had in jest. Ted does not encourage the minor child to participate in activities or ride rides that are not age appropriate or are not appropriate for her height. He certainly did not encourage her to get on rides that were 4 inches taller in the requirement than what she is. So that just doesn't seem to make a lot of sense to us, Judge. Also, the allegations that Ted does not provide a bed or a dresser for the minor child are very exaggerated and disputed. The minor child previously had a bunk bed. Now she has a standalone bed. There are times that the siblings have fallen asleep on the couch downstairs or on the air mattresses after watching movies, but at no point in time did she not have a bed or have the option of a bed. Adrian's correct that she may have chosen to sleep on the couch after the movie concluded, but that does not mean that she didn't have an adequate bed at the time. I also want to clarify the issue with the bucket that Adrian claims the child had to keep her clothes in. Ted believes this may be in reference to the tub that his wife uses to organize hand-me-down clothes, but this was certainly not the vessel that she was intended to keep her clothing in while she visited Ted. She has a dresser, as Adrian acknowledged. We don't see this as being an issue. Also, Judge, Adrian is supposed to be the one providing all clothes at Ted's home under the current parenting plan, though Ted has confirmed that they do purchase brand new underwear on behalf of the minor child when she needs it, so that also should not be an issue. Ted also wants to confirm that the child rides in a high back booster seat in his car as well, so it sounds like the same kind of car seat that Adrian uses with the minor child. And he also wants to address the parent-teacher conference references where Adrian says that he did not show up for a parent-teacher conference. He would counter that Adrian gave him the wrong time for that conference, so when he did show up, the conference was over or it hadn't occurred yet. So that was more a communication error between the parties than it was that he was not intending to, or that he was intending to, forego the parent-teacher conference. He intended to be there. Adrian also alleges a number of instances that she claims Ted violated the parenting plan. He disputes those instances. Ted has always ensured that Adrian is aware of the timing and locations of the vacations and extended trips. The bottom line is it is not practical for Ted and his family, while traveling with multiple kids, to stop and give Adrian play-by-plays of when they arrive, when they leave, of every step of their trip. It's just not practical. He did provide dates. He provided locations. He made sure she had the information that she needed. She was always able to contact Ted and his wife when necessary. Again, we don't see this as being a large issue. He's provided the information that he needed to. And in fact, the exhibits that she's attached prove that he did provide that information. It's also true, as we acknowledged in our motion, that Ted has not been present at parenting time exchanges a few times in the past 5 years. Those missed exchanges were due to workplace obligations, as we noted. Ted has always ensured that his wife was there at the correct time to pick the child up. No exchange has ever been missed or ignored, and Ted would offer the same flexibility to Adrian in the case that she could not be at a parenting time exchange, and recognizing that weekends with kids are busy and there's a need for flexibility. And we would implore Adrian to remember that flexibility is necessary in a co-parenting relationship. Next, Judge, the minor child's health is extremely important to Ted. He strongly disputes all of Adrian's suggestions that it's not important to him or that he hasn't done enough. As noted in our motion, some of these tensions have to do with the expensive therapy sessions that Ted is paying half of at this time, when he wasn't necessarily involved in the decision to begin those in the first place. Again, he wishes to be informed and involved. He's not comfortable just acquiescing to every decision Adrian makes without first receiving all of the necessary information. And we know that Adrian claimed today that she's given him all of that necessary information, and he disputes that he's received all of the things that he's asked to receive. But regardless, Judge, he has continued to pay for half of every uninsured medical expense under the parenting plan as it is required. He would argue that any delay in payment has to do with the fact that sometimes Adrian doesn't send them the receipt or ask him for payment until long after the occurrence has happened or long after she's been charged. Next, Judge, I just want to mention that, and I'll touch on this a little bit later too, but he acknowledges the child has an ADHD diagnosis. He does not dispute that. His wife has a child that has an ADHD diagnosis. They're familiar with that diagnosis. They're absolutely willing and they do support the minor child in that. Where they draw the line is when the ADHD is used as an excuse for bad behavior in their home. And obviously that is a thin line to walk, but that's what they're attempting to do. They're not trying to invalidate the fact that the child has a diagnosis. They recognize that she does. They are just encouraging the child to take accountability when she needs to for poor behavior and not to blame it on her brain or, and that's a quote from the child, or on her diagnosis itself. Judge Reed also emphasized that all the DCF investigations have been closed. They were all found to be unsubstantiated. These reports were analyzed by professionals, and the resounding opinion is the minor child is not in danger when she's in Ted's care. And that's the bottom line, Judge. Adrian also alleges that Ted doesn't spend time with the minor child during his parenting time. Ted strongly disputes this allegation. It's true that Ted works while he's exercising parenting time, but he works just the same as any other parent would. He spends time with the child when he's off of work. Further, Judge Adrian gives an example in October of last year when the child spent 5 days with Ted, and she states that 2 of those days were spent mostly in transit. Adrian seems to forget that those 2 days in transit were necessitated by the fact that she lives out of the state. That's not any fault of Ted's. We would also point out that a lot of Adrian's motion and her statements here today are based on things that she's concerned Ted, quote, may have done, and not things that she's provided actual examples or even claimed that actual action was taken on. And we want to point out, Judge, that Adrian's not been following the parenting plan to a T either. Like I said before, some flexibility is required with co-parenting. The ability of Ted to choose the long weekend was brought up earlier. He's supposed to be able to choose a long weekend each semester. This is under paragraph 7E of the existing parenting plan. Ted recognizes that the minor child and Adrian have prior obligations. He's happy to receive his long weekend when he can. He does his best to work amicably with Adrian to make those long weekends happen. But it should be acknowledged that when Adrian turns him down at every single turn for which weekend he can have, that is going to cause issues. They're simply trying to come to an agreement. And it's my understanding that at this point they've been able to do that. Seems that Adrian is worried about the long term, but with these long weekends, they've been able to make it work. The parenting plan also mandates that the parties spend reasonable time on the phone with the minor child. Adrian's phone calls during Ted's parenting time regularly last over an hour, which Ted accommodates, regardless of his opinion that the reasonableness of the length of time, it's not reasonable, frankly. And Judge, this comes back to flexibility. Life with children is fast-paced, it's always moving. Ted is flexible with Adrian's long phone calls with the minor child. He simply asks that Adrian be flexible with him. There will be days when the child is participating in other activities with Ted and his family, and she may not be readily available for an hour-long phone call. But Adrian needs to recognize that and not use these instances as reason to disparage Ted. As long as she's choosing to do that, however, Ted would request that specific guidelines be put in place for the length of time that these phone calls can happen. We suggest 30 minutes. We're open to negotiating that with Adrian later on. But it's just simply the case that an hour-long phone call on every date that she's set to call her mom is just too long. It cuts into Ted's already limited parenting time. Also, Judge, while Adrian's not asking for a change to the child support obligation, she uses the fact that he does not pay child support to disparage him in her motion. Again, that $0 child support number was set because of her choice to move the child out of the state. And in consideration of the fact that Ted facilitates travel of approximately 500 miles both ways 11 times a year to make these exchanges. Ted provides financially for the minor child while she is with him. She has everything that she needs while she's in his care. It's true that Adrian pays more for school supplies and extracurricular activities, Judge, but that's because the child lives with Adrian the majority of the time. And that's just the expectation. When she's in school and doing extracurricular activities, she's living with Adrian. Lastly, Judge, Ted wants to emphasize that the scared and anxious and meek little girl that Adrian claims returns to her every time that Ted has parenting time is not the same girl that Ted and his family see during his parenting time. Minor child is happy, she's involved in family activities, she gets excited to go on trips, she's enveloped into the sibling group just like the rest of the siblings are. Ted acknowledges that the child often has a demeanor change after she gets off the phone with Adrian. He believes that the same kind of change could be occurring after Adrian picks the minor child up at exchanges, but he strongly disputes that the minor child is unhappy or scared in his care. This is an 8-year-old little girl that we're talking about. She's navigating an emotionally charged situation between her two parents, and she's extremely young to be doing so. Ted has very serious concern that there's alienation occurring on Adrian's part based on the allegations in her motion that she stated today. The statements by the minor child in the therapist notes are also concerning because when asked to elaborate on some of her negative statements about Ted, the child is unable to do so, or she asks that the therapist ask her mom the question. We believe this shows that the minor child relies on her mom to determine her feelings and opinions towards Ted, which is extremely concerning. We would ask the court remind Adrian of her obligation to foster love and respect between the minor child and Ted. Now I've got a list of things that we are willing to agree to today, Judge, and that is the use of our family wizard, as I mentioned before. We're hopeful that that will help the parties communicate better, more effectively. Ted agrees the minor child can have a personal phone, but as we stated in our response, given that she's only 8 years old, we insist upon some specific parameters put in place to make sure she's not exercising excessive screen time and that she has that phone only to contact family members when it's necessary. Ted also agrees that more specific language should be added to the parenting plan to make times more clear. That's reasonable, and like I said, we're willing to negotiate that with Adrian, and also to make holiday time more clear and more fair between the parties. And then, Judge, we request that a 30-minute time limit be placed on the minor child's phone calls with both parties, at least for the time being, so they remain at a reasonable amount of time and do not encroach on important parenting time. Otherwise, Judge, Ted requests that the parenting plan continue as is, that the parties continue to exercise joint legal custody, and that Adrian's motion be dismissed because she's not shown us a material change of circumstances that would justify modification. We also ask that Ted be awarded attorney's fees due to Adrian's creation of unnecessary litigation, her failure to follow Supreme Court rules by attaching private medical records to a public document, and in the interest of fairness. The bottom line, Judge, is that Ted just wants to spend time with his child. He's fine with the parties parenting as they will. He recognizes they have different forms of parenting. He wants them both to have good relationships with the child and to continue maintaining the parenting plan that they have in place currently. They're not trying to make this complicated. We just want it to be a situation where both parties feel they have enough time with the child, given the fact that they live so far apart. Thank you, Judge.
Thank you, Ms. Stevens. Ms. Jackson, as the motioning party, I'll give you an opportunity for brief rebuttal. If you would.
I do have rebuttal, most of which was done within my response to the motion to dismiss. So you have that, you've already read that. I'm not going to rehash everything that that I had put in there. There were a couple of things that I think need to be clarified. Ms. Stevens stated that within my response, I did mention that I kept track of the puff count on her inhalers, both there and back, and it was stated that the emergency inhalers were not used. She has two. She has one that she uses 2 puffs AM and PM every day, and that's how it is prescribed to be used. And another is an emergency inhaler, a rescue inhaler. I don't anticipate that the rescue inhaler would be used unless she actually needed to. However, both of them remained unused and have for almost 2 years. It was actually indicated in a phone call with the child during this parenting time that this was the first time that her inhalers had been given to her in a long time. It was also mentioned that during a parent-teacher conference situation that it was indicated that I gave a wrong time. I can provide text message proof of the conversation that we had later where I text him and asked if he was getting on the Zoom or what have you, whatever avenue it was that they were using. And it was come to find out that he did not get the invite. I went to a different folder in the email. He had missed it, something like that, but it had nothing to do with me not giving him the right time. And I have text message proof of that I can provide if need be. It was again indicated that I requested a play-by-play regarding vacations. I'm not asking for him to show up somewhere and then text me, hey, we got here. I'm simply asking, you're going to be gone for an international cruise. What day are you leaving to your port in Galveston? What day does the ship leave? Where is the ship going? I've never asked for a play-by-play, only reasonable information that I believe is also reasonable should the situation be on the other side. If we were traveling anywhere. It was also indicated that I am told about every time that they travel out of state or travel in general. I don't believe I have been told outside of maybe 1, maybe 2 occurrences that they were traveling to Missouri. They regularly travel to Silver Dollar City. And I only find out because of phone calls with the child. She's the one that tells me. I don't get told about out of state travel otherwise. It was mentioned that I inferred that I made a comment about them trying to make her 4 inches taller. That comment was never made. I've never indicated 4 inches. The 4-inch difference was the height difference of different rides that I was referencing. She's not even close to the second one. So that one is, no one has indicated that one. The idea that she chose to sleep on the couch, yes, children do choose to sleep on the couch, but that is absolutely not what the child has indicated to me. It was, she chose the couch because it was the floor or an air mattress that did not remain blown up through the entirety of the evening. So yes, technically, I guess she did choose to sleep on the couch, but it was out of choice from the other choices that she had. The current parenting plan, Ms. Stevens was correct. It does state that it is to be me that provides clothing. But as I stated, we have not done that in a long time. And again, I can provide text message proof where numerous articles of clothing that I had sent were not being returned over a couple of different visiting time sessions. And I told Ted that I could not continue doing that if the clothing was not going to come back. And we were in agreement in text that he would then do that. That's an agreement outside of the parenting plan between both parties that I can provide proof of. And so the fact that it says that it's me no longer matters after we have made an agreement otherwise. There was mention in the motion to dismiss, and I mentioned it as well, the talks about the therapy. It was inferred that he was not informed about the beginnings of her therapy. It has to be. The state of Colorado, as I stated, has to have agreement and written permission from both parents, or in the case of this was verbal. It was a phone call between a therapist that she no longer has as she has moved on with Ted. It was a verbal agreement from both parents for her to start therapy. It was also indicated in the motion to dismiss that I have been party to these therapy sessions, and I have not. I was in one session out of all of her sessions at the behest of her therapist to try to facilitate her to be more comfortable in order to talk more. There were a couple of different times where her therapist told me that she had said, well, you just talk to my mom about it. I did not. I did not elaborate on anything that she had been asked. She simply took it into the next session to talk to her about it. And I do think it's important to realize that there is a difference between a child feeling uncomfortable talking about something and eventually opening up, as she has, and being dismissive or insinuating that she has to look to me to be validated in anything. I have not confirmed or denied any of the conversations that she has had with her therapist, and I have not been in any but one. It was also referenced within the motion to dismiss that there were family sessions that Ted was not privy to and that he was having to pay for. Again, no family sessions. And every invoice that I have sent very specifically states individual therapy. There is one, and I have checked through the invoicing that does specify it was a family session, which is the one in which that I was in. Otherwise, it is 100% her and her therapist. And usually she's not school-based, but she is based within the school. Aurora Mental Health and Recovery, as an entity, has a contract with Cherry Creek School District to place a mental health professional of varying degrees within each of the schools from elementary to high school, so that there is one there at all times. It runs through insurance, just the same as if I were to remove her from the school and take her to another building to do a session, but it happens during school hours, and it is usually a set. I believe this last semester was Tuesdays at 9:30. I wouldn't be able to be there for those anyway because I work. There was an indication that a lot of the reason that there's a delay in payment for his half of the uninsured medical expenses is due to me waiting to the delay that I have in giving him invoicing or not providing receipts. I will very, very strongly argue that there has only been one occasion in which a receipt had to be requested of me because I forgot to send it. Again, text message proof. I send the request through PayPal, and then I send a image, either scanned or a picture, which I make sure is readable in a group message that includes my husband, myself, Ted, and his spouse. that shows the correlation between the request and the receipt. A receipt has been provided every single time. And the reason for delay a lot of times is the therapy. Has been other times, but mostly the therapy. There have been times where it takes almost a year for it to run through insurance. And that's what I wait for. I don't bill him or provide invoicing to him until it has run through insurance. If it takes months, it takes months. They also don't get paid because I'm not going to pay them when they have not properly run it through insurance to give patient responsibility. So that's why it takes so long sometimes. But that doesn't account for why it takes 90 plus days to pay back. The examples that they allege that I am unable to provide is due to the fact that I am not in their home. I can't provide some physical proof of something when I'm not in their home. I have to go off of what is reported to me. And I have no reason currently to indicate that our child has lied to me. Sure. Children of all ages embellish. They like to tell tales and such. But when it comes to a crying child who asks not to go back due to these issues, I take that into a different type of consideration than something that seems far-fetched. But I also don't just take what she says for face value. If anything is reported to me by our child, I then continue to ask questions. You know, especially if something sounds very, very strange and very out there, I'll say, well, are you sure that that's what was said? What is the exact wording of what was said? What was the conversation? Because I think that context is important, especially when talking to a child who is trying to navigate a lot of different emotions and the emotions of other people, because that is inherently something that you must do as a child, whether it's right or not, you take that on. I very much oppose that I disregard what he wants or that I argue with him at, quote, every single turn. As was stated, for the most part, up until fall of 2023, we were able to resolve the issues of specifically the long weekend. But I have not at every single turn told him no, nor have I violated the parenting plan in requesting that one weekend not be touched, which was for a good reason, in my opinion, since I had gotten married. And I put it in my response, but I think it is important to say that there was the fall of 2022, Ted got married. And it was not done during his designated long weekend. He had an additional parenting time for that wedding. And I had no reason to argue. I never even made a comment about it. The comment reasonable in reference to access to a phone within the current parenting plan, the term reasonable that is being used is in reference to access to a phone call. It is not being stated as the amount of time that should be allowed. And I've already discussed what my feelings are for trying to put a time frame on it. I don't think we should be looking at any of it as it is Ted's time or Adrian's time. It is Joey's life. And I think it is important for her to be able to have that access to both parents at all times. And honestly, I really think that if she was able to, send a text every once in a while, I don't think she'd have a reason to want to be on the phone. I don't force her to stay on the phone. I actually have tried to get her off of the phone. Like, hey, do you want me to let you go? Hey, we haven't had dinner yet, so I'm going to go do that. Oftentimes I get a sad face of sorts, or no, I don't want you to get off the phone. Things like that. I don't force her to stay on the phone. And I do think that that is important to note. And I don't think that there should be a limit of time. I mentioned it in my response, but the comment about no child support was not to disparage Ted. That may have been how it was interpreted, but for clarification, it was not to disparage Ted in any way. I'm not arguing that there's child support or why there's no child support. That's fine. The comment was to show the disparity in how he handles financial situations between one child to the next. He has no court-ordered child support and he has no court order with another child of his. However, that child's mother has told me that when it comes to extracurriculars or school supplies or medical or whatever, it's a 50-50 split, and he's never had an argument to do so. And he's never waited so long to pay her back or vice versa. It was just to show the disparity in how things are handled, which goes to the comment that because she lives with me, of course, I'm the one paying for everything. There is, again, no court order between the other child, so there is no supposed 50-50 or any sort of percentage split, but there is, it is an equitable adjustment of finances in that situation, but not so much in mine. That all it was to do was to comment on that. There is no way, in my opinion, for the current parenting plan to continue without modifying it. So having put in a full motion to dismiss seems inaccurate. Maybe a partial motion to dismiss may have been more appropriate, because if we're going to be changing anything about the parenting plan, then dismissing the entirety of everything wouldn't really work out. It's great that there are certain things that can already be agreed upon. That's wonderful. But I do think there's a little more input that should be needed outside of simply a back and forth, and maybe looking at some of the parenting plan that I have already proposed, seeing if there is verbiage that can be taken, as opposed to trying to only just rewrite what is in there, because I did keep everything in there. She is right. I did take out all of the explanation as to why there was no child support, because again, neither side is arguing that there's zero child support or why. So I just didn't transfer that over. It was just an agreement. There is no child support, and that's all there was to it. The last comment being that she is a different child there than she is here, and I do mention it in my response that it has been worked with both her therapists for trying to use it as a coping mechanism, as well as she's able to acknowledge that she does it. She masks, emotionally masks. She does it at school as well, because unfortunately it's the only way when you have an emotional dysregulation issue like ADHD, you do have to mask sometimes, because otherwise kind of all over the place. And anyone who knows things about ADHD knows that to be the case. So it is, and I would certainly never say that she obviously doesn't mask ever at home either. It's something that you have to learn how to navigate, but she does indicate that she masks a lot because she does not feel that it is an emotionally safe environment for her to express herself in all of the ways that she would like to. That lack of emotionally safe environment that she feels is what I am hoping can change to be more positive for her, because if she was able to talk to Ted about how she feels, I think that this would be a completely different situation. I believe that is all of my rebuttal comments.
All right. Thank you, Ms. Jackson. All right. I did have an opportunity to review the contents of the court file in preparation for today's hearing. It is a very lengthy court file. I went through the extensive motion to dismiss, or the motion to modify, filed by Ms. Jackson. I went through the motion to dismiss filed by Ms. Stevens, and I went through the response to that motion to dismiss, and I've now had an opportunity to listen to the arguments and statements of counsel and the parties. The main issue, or probably the most substantial issue raised in the motion to modify, is the proposal to change from joint legal custody to sole legal custody. The standard is whether there's been a material change of circumstances, and that the change of circumstances is of a substantial and continuing nature that makes the terms of the initial decree unreasonable. The information that's been presented, the court doesn't find those to be material changes of circumstances that make a joint legal custody arrangement unreasonable or unworkable. The issues regarding the ADHD, the medical issues, which are a large basis of the argument, not the sole basis, but a large argument. I think those are out in the open. I think those are workable. I haven't seen anything that would lead me to believe that the child's health, either physical or mental, is at a substantial risk by anything that's occurred at this point. I think a lot of these issues can be remedied with better communication between the parties. And I think the use of the family app to upload all of the information, including therapists, appointments, will be helpful in hoping to assist the parties in having all of the relevant information. But again, I don't think there's enough here to warrant a change of the joint legal to sole legal custody, or to reduce the parenting time that's been proposed from 8 weeks down to 5 weeks in the summer. I think it's important that the minor child have that parenting time with her father. The other issues that have been raised, this is a parenting plan by admission of both parties that does need some tweaks and modifications. I'm not inclined to dismiss that. There's a lot of these issues that I think are going to be important as the child has gotten older since it was initially ordered, that are going to be important moving forward, or these parties are going to continue to engage in this type of litigation, which is unfortunate. But if I'm not going to rule on those now, I think the best course of action, if the parties believe they can engage in meaningful negotiation to try to work through the proposals or language tweaks in language that have been proposed, would be best for the parties, because they're coming to that agreement on their own. I'm more than happy to, if you all are unable to come to an agreement on any of these issues, I'll be more than happy to make the decision. But I'd like to give you all an opportunity to try to work those out on your own first. Ms. Stevens, is that something you're willing to do?
Yes, absolutely, Judge.
Right. And Ms. Jackson?
Unfortunately, I don't think that it's going to go well. Just personally, given that I have obviously stated how I feel about it, he has stated how he feels about it. I don't think that it is going to go well. We may end up right back in front of you. But if the decision is for us to
what
do
I
it,
was going to suggest was setting a hearing out about 30 days to give you all an opportunity to engage in meaningful negotiation. You all may be closer than you think on some of this stuff. Maybe not. If that doesn't work, then we come back and I'll just go down each of the issues. I wrote pretty extensive notes and I'll issue a ruling. But I just thought if you all can come to an agreement, that might be better for each of you than me ordering something that neither one of you feel might be workable. So if it just looks like it's not going to work, then that's fine. We'll come back at the date I'm going to set, and I'll just run through them and make the decision.
that's fair.
So however you all feel it's easiest to communicate, if that's by email, by text, or by phone call, I'll leave that entirely up to you. And I'll set a hearing about 30 days out. If you all have come to an agreement on all of the outstanding issues and wish to have that journalized and we don't need to come back, we can do that. If not, if you all could submit what you feel the remaining issues that need to be resolved. If you could do that within 3 days of the hearing we're going to set, then I'll have time to go back over everything in preparation for that hearing. And I don't expect this to be further argument. I just feel the unresolved issues should be presented and I'll rule on those. I've heard the arguments in support of all of those positions. I have good notes. So, Angela, if you could provide a date about 30 days out.
Judge, want me to go a little further out than that, but I have the end of August 27th at 10.
August 27th at 10 o'clock.
During the day, man, 'cause I don't know.
And we can do that by Zoom again.
Okay, so yeah, then better, yeah.
That works for us, Judge.
And Ms. Jackson, does that date and time work for you?
Yeah.
August 26th.
All right, we'll do that by Zoom. If, like I said, if 3 days prior to that hearing, any unresolved issues, if you could provide those through Angela, then I'll look at those prior to that court date.
That sounds great, Judge. Thank you. Would you like me to prepare a journal entry?
Well, I'm thinking if it'd be best to wait and do it, or go ahead and journalize what the court's ordered today. If you want to prepare just an order memorializing what occurred today, I think that'd be appropriate.
Sounds good. I'll do that, Judge.
All right, Ms. Jackson, anything else today?
Would it be out of line for part of that journal entry to include us beginning use of the parenting app now? Obviously, discussions about this will go through his representation, but there will obviously still have to be communications outside of this discussion. If we could start utilizing that app, it would be, I think, beneficial for everyone.
I think I agree, Ms. Stevens.
Yeah, that's great, Judge. We're happy to do that.
All right, and let's figure out which app is going to be used.
We typically work with our family wizard, Judge, but I'm not opposed to any other suggestion that Ms. Jackson has.
Ms. Jackson?
That is the application that I have heard most of. I've heard of a couple, but I've not used any of them. So,
Okay, it's a fairly popular one. I think it's good. So if you all want to take whatever steps you need to get that going, I'm not sure what it takes to get it up and running, but I think that'd be good for both parties. Anything else, Ms. Jackson?
that's all.
All
That's
right. If there's nothing further, we'll be in recess today, and we'll either see everybody back in August, or I'll look for an agreed upon journal entry for the remaining issues.
Great. Thank you, Judge.
We are in recess.